Let me take a moment to speak directly to those of you who are United States citizens, lawful permanent residents holding your green card, and anyone who's been waiting patiently for a decision on a family-based petition. I know that over the past few weeks, your social media feeds have probably been flooded with headlines and videos talking about new salary requirements, about $25,000 thresholds, and about changes that seem to appear overnight. Some of these headlines are designed to get clicks, and I understand how that can create confusion and even fear. So before we go any further, I want to be very clear about my goal today. I am not here to scare you. I am not here to tell you that the sky is falling or that your family reunification dreams are over. My goal is to explain this calmly, truthfully, and in plain language, the way I would if we were sitting together in my office, and you had just asked me what all of this really means. Now, I want to mention something important right at the start. Everything I share with you today is for informational and educational purposes. This is not official legal advice tailored to your specific case. Immigration law is personal, and every family situation is different. If you have concerns about your own petition or application, I always encourage you to speak with a qualified immigration attorney who can review your documents and give you guidance based on your unique circumstances. That said, what I can do here is give you a clear, honest picture of what these financial requirements actually are, how they work, and why, in most cases, though they are not as terrifying as the viral posts might make them seem. So let's take a breath and talk about what is actually happening. The confusion right now centers around something called the Affidavit of Support, which is a form that sponsors file when they are trying to bring a family member to the United States through adjustment of status or consular processing. This is not a new form. It has been around for decades. The form is officially known as Form I-862, and its purpose is to show the United States government that the sponsor has enough income or assets to support the person they are bringing over, so that the immigrant does not become a public charge. In other words, the government wants to be sure that the new arrival will not need to rely on government benefits to survive. This is a long-standing policy, and it is grounded in federal law. Now, the sponsor's income requirement is based on something called the Federal Poverty Guidelines, which are updated every single year by the Department of Health and Human Services. These guidelines are not set by immigration officials. They are not political decisions made by any one administration. They are economic benchmarks that reflect the cost of living in the United States, and they are used across many government programs. For immigration purposes, the sponsor must demonstrate that their household income is at least 125% of the federal poverty guideline for their household size. For sponsors who are on active duty in the U.S., military, and sponsoring a spouse or child, that threshold drops to 100%, but for everyone else, it is 125%. Let me put this into real numbers so you can see what we are talking about. The 2026 Federal Poverty Guidelines, which were published earlier this year, set the baseline for a household of 2 people at around $20,440. When you multiply that by 125%, you arrive at $25,550. That is where the number in the video title comes from. This is the minimum annual income that a sponsor needs to show if they are sponsoring just one person and the household size is 2, which includes the sponsor and the immigrant. If the sponsor has additional dependents, children, other family members, or if they are sponsoring more than one immigrant at the same time, that number goes up. For a household of 3, the requirement is higher. For a household of 4, it is higher still. You can find the exact chart on the USCIS website, and I encourage you to look at it so you know exactly where your household falls. Now, let me address something that I see causing a lot of panic online. People are asking, does this mean I need to have $25,000 sitting in a bank account right now? The answer is no. This is not about having a lump sum of cash. This is about annual income. The government is looking at what you earn in a year from your job, from self-employment, from Social Security, from pensions, and other lawful sources of income. If you filed a tax return last year and your adjusted gross income was at or above the required amount for your household size, then in most cases you meet the requirement. It is really that straightforward. You do not need to be wealthy. You do not need to own property. You need to show that you are earning a stable, lawful income that exceeds the poverty line by 25%. What if your income falls short? Let me reassure you that there are legal and legitimate ways to make up the difference. First, you can combine your income with the income of other household members. If your spouse works and you file taxes jointly, their income counts. If you have an adult child living with you who earns income and is willing to be listed on the Affidavit of Support as a household member, their income can be included as well. Second, you can use assets. The government allows you to count assets such as savings accounts, stocks, bonds, and even the equity in your home. The rule is that assets are valued at 1/5 of the income shortfall, or 1/3 if you are sponsoring your spouse or minor child. So if you are $5,000 short of the income requirement, you would need to show $25,000 in assets, or $15,000 if you are sponsoring a spouse or child. This gives families with savings or property a real opportunity to meet the requirement, even if their paycheck alone does not quite get them there. There is also the option of using a joint sponsor. A joint sponsor is someone else, often a family member or close friend, who is a U.S. citizen or green card holder, who meets the income requirement on their own, and who is willing to sign a separate affidavit of support for your family member. The joint sponsor does not need to live with you, and they do not need to be related to the immigrant. They simply need to meet the income guidelines and be willing to take on the legal obligation to support the immigrant if necessary. This is a very common solution, and it is fully accepted by USCIS and the consular offices abroad. I want to emphasize something that often gets lost in all the noise. These income requirements are not new, they have existed for years. What has changed is simply the dollar amount, because the federal poverty guidelines are updated annually to reflect inflation and the cost of living. The number goes up a little bit every year. This is normal. It is not a sudden policy shift. It is not a crackdown. It is an adjustment based on economic data. So if you are seeing videos that make it sound like there is a brand new rule that just appeared out of nowhere, I want you to understand that the framework has been in place for decades. The numbers change, but the system does not. Let me also talk about what happens if your petition is already pending. If you have already filed your I-130 petition and it is sitting with USCIS, or if you are waiting for an interview at a consulate, you will be asked to submit the Affidavit of Support at the appropriate stage. For adjustment of status cases filed inside the United States, that is typically when you file your I-485. For consular processing cases, it is submitted closer to the visa interview. The income requirement that applies to you is the one that is in effect at the time you submit the Affidavit of Support, not the one that was in effect when you first filed the I-130. This is important to understand. If you filed your petition 2 years ago, but you are only now getting to the stage where the affidavit is needed, you will need to meet the current guidelines, which means the 2026 numbers, if you are filing it this year. But again, for most people who are working full-time, who have been filing taxes, and who have stable employment, this is not an insurmountable hurdle. Let me address another question I hear often. What if I am retired? What if I am on Social Security? Social Security income counts. Pension income counts. Disability income counts. Any lawful, regular income that you report on your tax return can be used to meet the requirement. If you are retired and your Social Security benefit is lower than the threshold, you can still use assets, or you can bring in a joint sponsor. The law is flexible in that sense. It gives you multiple pathways to demonstrate financial ability. I also want to talk about the emotional side of this, because I know that for many of you, these numbers are not just numbers. They represent your ability to bring your spouse home, to reunite with your parents, to have your children grow up in the same country as you. The waiting has been long. The uncertainty has been exhausting. And when you see a headline that says you need to earn more than you thought, it can feel like the goalpost has been moved yet again. I want you to know that your frustration is valid. Your anxiety is understandable. But I also want you to know that the system, as slow and complicated as it is, does have rules, and those rules are designed to be met by ordinary working families. You do not need to be rich. You need to be stable. You need to show that you can support your loved one without relying on public assistance. That is the standard, and it has always been the standard. One more thing I want to clarify. There is a difference between being delayed and being denied. If your income is slightly below the threshold, that does not mean your case is automatically denied. USCIS or the consular officer may issue a request for evidence, asking you to provide additional documentation, to clarify your household size, or to show additional assets. You will have an opportunity to respond. You will have time to gather a joint sponsor if needed. The system is slow, but it is also structured. It is not random. It is not designed to trap you. It is designed to process applications according to law, and that includes giving you a chance to meet the requirements. So what should you do right now? First, take a breath. Second, gather your documents. Pull out your most recent tax return. Look at your adjusted gross income. Count the people in your household. Go to the USCIS website and find the current federal poverty guidelines chart. See where you stand. If you are above the line, you are in good shape. If you are close but not quite there, start thinking about whether you can include another household member's income, whether you have assets you can document, or whether you have someone who could serve as a joint sponsor. Third, if you are unsure, talk to an immigration attorney. A consultation can give you peace of mind and a clear plan. I know this is a lot to take in, and I know it can feel overwhelming, but I want to leave you with this. The truth is that most families who are going through this process do meet the income requirements, or they find a way to meet them with the tools the law provides. The viral videos that make it sound like no one can sponsor anyone anymore are not telling you the full story. They are focusing on the number and not the context. The context is that this is a standard that working families meet every single day. The context is that the law gives you multiple ways to demonstrate financial ability. The context is that you are not alone, and you are not without options. If you found this video helpful, I hope you will share it with someone who might be going through the same questions. Leave a comment below, and let me know where you are in your immigration journey. Are you waiting for an interview? Are you gathering documents for an affidavit of support? I read the comments, and I learned from your experiences. Thank you for watching, and remember, take it one step at a time. You have come this far, and you can keep going.